Hi, and welcome to today's presentation on the required documents to close escrow in a probate sale. This video and presentation is specifically for personal representatives, whether you've been appointed as an administrator or an executor, or you're petitioning the court for that purpose. This video will outline real quickly over the next 10 minutes or so three required documents that are needed to close escrow for a property that's being sold throughout the probate process. And one quick disclaimer, I just want to let you know that I am not an attorney, nor am I giving any legal advice, but I am a probate specialist. I'm a real estate agent who's been licensed for over 20 years, and I have specialized training in probate real estate sales. So without further ado, let's go ahead and get started. And the reason why I indicated that I have specialized training is because it's important to know, if you don't know already, that probate real estate sales are vastly different than a regular real estate transaction. There are a lot of different legal requirements that have to be met in a probate real estate transaction. There's many notices that have to be supplied to the heirs and the beneficiaries of the estate and creditors of the estate. There are several court hearings that take place and conducted by a probate judge. And if something is not correct or delayed, the timeline of the probate process is extended drastically, and that really negatively affects the distribution and extends the distribution, the monetary distribution to the heirs and the beneficiaries. But today we're going to focus specifically on three required documents that are needed to close escrow for a house or property being sold in probate. The first required documents we refer to as the certified letters. And the certified letters can either be the letters of testamentary or the letters of administration. I have a very detailed video that you can access through my probate resource guide webpage that I'll share with you how to access that at the end of this presentation. But really quick, the difference between the letters of testamentary and the letters of administration is just if there was a will included in the estate, if the decedent had a will or did not have a will. If there was a will, then an executor would be appointed to administer the estate, and they would be issued letters of testamentary. If there was no will that the decedent had, then an administrator would be appointed, and they would be issued letters of administration. For our purposes, these two letters are synonymous, and they both give the executor or the administrator the same authority to act on the decedent's behalf in administering this estate. And it basically gives the administrator or the executor authority to conduct the financial decision making and financial actions on the estate's behalf. Specific to a real estate transaction, it would allow the personal representative, also known as the administrator or the executor, it would give the personal representative the authority to enter into a listing agreement to get the property listed on the multiple listing service and all the associated marketing websites such as Zillow, Realtor.com, etc. It would also allow the personal representative to enter into a purchase contract when an acceptable offer is received by the estate. And then ultimately it would allow the personal representative to sign the grant deed to transfer the property to the buyer and accept the funds for in exchange for the sale of the property. And then once the funds are received, all that money would go into the estate's bank account and be held for final distribution. The next required document is called the Notice of Proposed Action. And we also refer to this by its acronym NOPA or NOPA. And the Notice of Proposed Action is a document to notify all the heirs and the beneficiaries of this estate of any action that the personal representative is taking on behalf of the estate, such as those three situations I gave you examples of regarding the sale of the property of the estate. So the notice of proposed action, anytime one of those three actions, whether it's a listing agreement or a purchase contract or a grant deed, the heirs would be notified by this form, by this NOPA form, and they would have 15 days to object or consent. There is a 15-day expiration, if you want to call it that, in where if the heirs do not object within the 15-day period, then that is equal on the courts, from the court's perspective, that equals that the heirs consent to that action. The heirs can object. As I said, they're on the back of the form. There's a box to check to object. And if any heirs object to the proposed action that the personal representative is taking, then that action would not be allowed to move any further until there was a court date scheduled and a hearing was held and a judge made a decision and ruled on behalf of the estate whether that action can go forward or not. And if any heirs object, it really delays the timeline of the process, the total process, and thereby the distributing the monetary equivalent of the liquidated assets. In the event that all the heirs do agree and they want to accelerate the timeline of the NOPA, the Notice of Proposed Action, there is a waiver that can be signed by all the heirs and beneficiaries, which would eliminate that 15-day period, and you could proceed to the action even quicker. So we have the certified letters, the Notice of Proposed Action, and the final document that's needed is called the Federal Tax Statement Letter, and it's sometimes referred to as the comfort letter. And this is a letter that is generated and comes from the estate attorney. And basically what this letter indicates is that the estate is in good standing with federal taxes. In some cases, if the estate is not represented by an attorney and the executor or administrator is handling it themselves, which can be done, this is called a pro per case. This letter would come from the personal representative, being the administrator or the executor. Either way, this letter satisfies the title company so that they can ultimately issue title insurance at the close of escrow. So those are the three documents that are required by the title company to be able to actually get a property under contract and eventually ultimately close escrow, whereby those money received for the sale of the property can then be deposited into the estate bank account, and the estate can proceed to final distribution. If you have any questions on any of the information I just reviewed, or anything further, go ahead and contact me anytime at no obligation. My phone number, you could call or text. There's my email address, which is available for communication, and my website is there. And I have on my website a scheduling link where you could book a no obligation phone call or even a Zoom meeting with myself. As well as the QR code on the screen will take you to the probate resource page that has not only this information, but much, much more information for a personal representative to help you navigate the real estate side of the probate process. And again, there's no obligation. Even if you decide to go with another real estate agent, I'm here to help and provide guidance as much as needed. So I really wanted to extend my condolences for the loss of the loved one that you're experiencing. And I know firsthand how difficult, stressful, and overwhelming this process can be. And I just want to let you know that I'm here to help in any way I can. So I hope this information was helpful. And if you need any help, please don't hesitate to reach out and contact me.